Everyone, please be seated. Good morning, everyone. I request all the dignitaries to please come forward for lighting of the lamps. And two student volunteers and teaching and non-teaching faculty for lighting. Thank you, everyone. A very good morning and warm welcome to respected Principal Madam, honorable guests, esteemed faculty members, and dear friends. I am Navjot Kaur Nanda from BLLB 4th year. I am very pleased to be here and much more delighted by everyone's presence at this special event. Today is the beginning of something very remarkable. We've gathered to commence lecture series LEX SCIENTIA 2023 by Dr. Diva Patil Law College in collaboration with Randive and Randive Associates. The very first topic of our first lecture is Women and Law, Recent Judicial Trends. LEX SCIENTIA 2023 aims to advance the understanding among aspiring law students as well as people from among the legal field. Scientia means knowledge or expertness. In this lecture series, we would have the privilege to gain knowledge from experts of legal field who have gained command over it by having years of experience. Now let us proceed with the event. At first, I would like to call our Principal Madam, Dr. Ujjwala Shinde, to come and give welcome address to our respected guests and audience.
Very good morning. Respected dignitaries on the dais, Dr. S.E. Avhad sir, Advocate Randive sir, advocates from various bars, Pimpri bar, Shivaji Nagar bar, teaching and non-teaching staff of the college, and my dear student friends. I welcome you all to this inaugural ceremony of LEX SCIENTIA, that is the knowledge of law. So, today we can say it is certainly a very special day, as in collaboration of Randive and Randive Associates, we are commencing a lecture series. The vision behind commencing such law series is very specific. Law cannot be studied in isolation. It is always read and interpreted contextually, considering the changing need of time. Deliberation of social, political, judicial perspectives of legal provisions are inevitable to understand the law critically. Study of versatile dimensions of law and its intersections in other disciplines is emphasized by National Education Policy 2022 also. Therefore, having a mission to provide the critical thought process amongst law students and advocates, this lecture series is initiated. For inaugural and for first lecture in the series, we could not imagine other than Dr. Sudhakar Avhad sir, because I always think that he is not only an advocate, but he is an elderly in the family, that we always go to him for consultation and guidance. We are truly grateful to Avhad sir, and as he is a teacher of a teacher, I always say, for accepting our invitation for the program. The theme of this lecture is certainly a topic in vogue. Recently we have celebrated Women's Day. On the other hand, United Nations Development Program in 2017 reported that women own less than 20% of the world's land. Now it's time to give them equal property rights. We are really fortunate to listen Dr. Avhad sir, his views on women and law, recent judicial trend, with special reference to Section 6 of Hindu Succession. I would also like to thank our management, especially Dr. Somnath sir, for his wholehearted support for every activity of the Law College. I am thankful to all the participants that they are present here to listen the recent judicial trend. Thank you.
Thank you so much, ma'am, for a very warm welcome. For our very first lecture, we have a very accomplished resource person who is a senior advocate. Advocate Dr. Sudhakar Avhad sir. Avhad Sudhakar Eknath Rao, born on 10th of March 1953 in Chincholi in Ahmednagar district, Maharashtra. He has passed his SSC in 1970 from Dada Chaudhary Vidyalaya, Ahmednagar, with first class and secured first rank in school. He has passed his BSc examination in first class with distinction in 1974 from Modern College, Pune. He passed his LLB examination in 1977 from Pune University and secured first rank in second and third year LLB from Pune University, and passed his LLM examination in 1976, securing first rank. Sir has been awarded Tulpule Gold Medal and other prizes for outstanding performance at law examinations. He has been conferred with PhD in law for his thesis submitted to Savitribai Phule Pune University on the topic Global Dimensions of Human Rights and Evaluation of Fundamental Rights under the Indian Constitution. Sir has been teaching law since 1977. He has been coaching law students in all the subjects and conducting coaching classes for judicial services examination. There are few thousand advocates practicing throughout India, being his past students of his law classes. There are more than 250 judges in Maharashtra state, being students of his coaching classes for judicial services examination. He has been a practicing lawyer since 1977, having a standing of 45 years of experience, and practiced on National Green Tribunal, civil, criminal, revenue, cooperative sides with specialization in land laws. He has participated in a number of conferences at state and national level, has submitted his papers at such conferences, and has been a member of Land Titling Committee by Government of Maharashtra, and delivered lectures at almost all district bar associations and some taluka bar associations in Maharashtra state. Has participated in continuous legal education program by Bar Council of Maharashtra and Goa at various places. Adding to his various achievements, he has written a couple of books for law students, such as Draftsman for Practitioners, Law of Notices for Practitioners, Judicial Services Examinations, Real Estate Development and Regulation Act 2016, Handbook for Law Entrance Exam CET. And he has a collection of poems called Kavya Suddha. Sir has also held the office of Chairman of Bar Council of Maharashtra and Goa from 2002 to 2003, and has been a member of Bar Council of Maharashtra and Goa from 1998 to 2003. He has worked as a legal advisor for Pune Municipal Corporation and many state and national level organizations. Sir, it is really an honor to have you here with us delivering this lecture. Thank you so much on behalf of Dr. D.Y. Patil Law College and Randive Associates. Let us have a huge round of applause for our honorable guest. Now, I request our respected Principal Madam, Dr. Ujjwala Shinde, to kindly felicitate our honorable guest, Dr. Sudhakar Avhad, sir. Thank you so much, ma'am. Now it is my privilege to speak about my very own college, Dr. D.Y. Patil Law College, which has left no stone unturned to contribute for legal fraternity by organizing such events. Dr. D.Y. Patil Law College, Pimpri, was established in the year 2001 under the patronage of Honorable Chairman Dr. P.D. Patil, sir. The college is affiliated with Savitribai Phule Pune University and recognized by Government of Maharashtra and Bar Council of India under the auspices of Dr. D.Y. Patil Unitech Society. The college is situated in Pimpri suburb and is one of the premium colleges in the vicinity. Since 2001, college has achieved various milestones like successful organization of national level moot court competition 2019, establishment of Legal Aid Center in collaboration with District Legal Services Authority Pune in 2021, successfully organizing National Virtual Mediation Competition 2021. The college is accredited by ISO and college has received many awards like Swachhata Action Plan Institution, Certificate for Establishment of Innovation and Startup Cell, Center for Innovation, Incubation and Linkage, Savitribai Phule, Pune University 2021. Attending a 5-day full-time Civil Defense Training Workshop, SPPU, in March 2022, and many more. These versatile achievements of the college were certainly not possible without the right vision and apt guidance of a beloved and respected Dr. Ujjwala Shinde ma'am. For recognizing ma'am's valuable contribution in this field, Randive and Randive Associates wishes to felicitate madam. I request Anant Randive sir to kindly felicitate Ujjwala Shinde ma'am. Thank you so much, sir. Thank you so much, ma'am. So, this initiative of lecture series has been taken by our beloved Advocate Anant Randive, sir, who is the Managing Director of Randive and Randive Associates, which is a reputed, skilled, professionally managed law firm with years of experience. The main areas of the firm includes business law, corporate finance, capital markets, corporate litigation, financial services, banking, agriculture, litigation, arbitration, taxation, real estate, infrastructure, consumer protection, inheritance, matrimonial issues, criminal litigation, environmental protection, drafting of deeds and agreements, appellate work at high courts and supreme courts. With a team of highly qualified and experienced legal professionals, the firm stands out for its approach towards understanding the requirements of client and providing unique solutions with quick turnaround time. Randive and Randive Associates has a pan-Maharashtra presence with offices in Pune and Aurangabad. The firm represents the Pune Municipal Corporations, Pimpri Municipal Corporation, Pune Metro and State of Maharashtra as the appropriate authority of PCP NDT cases also. The firm also provides legal advice on various topics whenever asked by the corporation. The firm is not only committed to providing legal services but also believes in creating great lawyers for future. As an effort to providing legal education through practical exposure, they welcome young and budding lawyers to have a real-time experience in this field and continuously provides internships to students from various law colleges in Pune and across India, like Dr. D.Y. Patil Law College, Army Law College, ILS College, Navamal Firodia College, Shivaji Maratha Law College, MIT Law College, Marwadi University, and students from Rajkot, Gujarat, Jindal Law School, Mussoorie and Dehradun, MP Law College, Aurangabad, etc. On a regular basis, the firm also organizes and has been a jury at various moot court competitions. Randive and Randive Associates take pride in being the official sponsors for the annual National Moot Court Competition organized by Dr. D.Y. Patil Law College. Since its inception, they have always believed in the highest level of integrity, followed a people-oriented approach, and given back to the society whenever possible. At Randive and Randive Associates, the principle of client first is followed for providing reliable and highly effective services. The spirit of continuous learning, strong tenacity, and continuous innovation is the backbone of Randive and Randive Associates. Let us have a huge round of applause for Advocate Anant Randive and his firm Randive and Randive Associates. I now request our respected Principal Madam to kindly felicitate Advocate Anant Randive, sir. Thank you so much, ma'am. Thank you so much, sir. Let us not wait anymore and begin with our session. I kindly request our honorable guest, Advocate Dr. Sudhakar Avhad, sir, to kindly commence the lecture.
Honorable Principal, Dr. Sindhe Madam, faculties and lecturers, DY Patil Law College, my esteemed colleague and Managing Director of Randive and Randive Associates, Advocate Professor Anant Randive, Advocate Rohan Randive, student friends, brothers and sisters. I'm very happy to be associated with you this morning. I've been called upon to participate the opening lecture of the series based on women and law. Especially, I have been assigned the task of exploring the subject based on Hindu Succession Act and the woman empowerment, or in short, rights of a female under Hindu law. Before I come to today's topic, I will like to say a few words about this firm, Randive and Randive Associates. We have taken this initiative in collaboration with or in joint venture with Dr. D.Y. Patil Law College. Especially these Randive brothers, coming from a very remote and rural area in Maharashtra state. They have been established in Pune with all adversities, difficulties, problems, and they have been flourished into a rather national level firm in Pune, operating at Pune and at Aurangabad. These brothers, they practice from Taluka level to Supreme Court of India, and as such, they have been crowned with the prestige in this legal profession. I congratulate Randive and Randive Associates for having this collaboration with Dr. D.Y. Patil Law College for the purpose of today's lecture series, that is Women and Law. You'll find, friends, such sometimes national level firms having standing of hundreds of years or couple of decades. They take such pride in commencing such lecture series. I really express my gratitude to this institute for allowing Randive and Randive Associate to associate with them. Here I find the blend of rural and urban areas together to deliver the goods to the customer of the goods that is the law students. I also congratulate the principal, Dr. Ujjwala Sindhe madam, for commencing such lecture series. Friends, I have been in this legal profession and this law teaching for last 46 years. I have seen in most of the law colleges, only theoretical subjects are taught. Law student, after becoming a lawyer, he is not knowing how to practice and what are the practical difficulties. And next, at least 5 years have been invested in learning how to practice. This institute, I am really happy that they have started such courses or such lecture series wherein students at the budding level, they have been enlightened as to how the practical aspects are also to be seen. They are teaching you or they are commencing such a lecture series in collaboration, not only teaching you the theoretical subject, but also taking you through the course of law and the plethora of the judgments by which law has been established and settled in India and especially in Maharashtra state. On this backdrop, friends, I will enter into the subject, that is women empowerment, women and law, and especially in the light of the Hindu Succession Act 1956. Friends, this goes long back, at least few thousands of years back in Indian soil. Especially, rather there is a journey from couple of thousand years, what we call to be ancient period, till 11th August 2020. There is a long span wherein rights of female, they have been discussed and decided and have been crystallized by the Supreme Court of India in a very recent judgment based on this topic. The judgment has been delivered by the Supreme Court on 11th August 2020. This journey of a couple of thousands years we'll discuss in say 1 and 1.5 hours. I hope all of you will respond to this topic if I exceed a little beyond the given time. As per the schedule I was looking into, at 1 hour's time has been given to me. 45 minutes time has been given to me. But friends, a lecturer may be satisfied with 45 minutes. But here is a lecturer plus advocate. So my time is going to extend certainly beyond 45 minutes. So you please bear with me. But today, when going home, you will find you know something which a lawyer of at least 10-15 years standing knows. So I will make you conversant with all these process and procedures of the courts, including the Supreme Court of India, and as to the woman empowerment. To understand this process of woman empowerment in India, let us go back, especially as to Hindu system, couple of centuries back, thousands of years back. Story starts with the Hindu system, ancient Hindu system. As per the ancient Hindu system, especially in respect of proprietary matters, you will find amongst Hindus, there were different categories. Especially, there were two categories of Hindus. There were two classes of Hindus. There were two schools of Hindus. And especially, this entire episode goes to at least 3,000 to 4,000 years before Christ. And this is with reference to the concept of the Vedas, Upanishads, and Puranas. Hindu law, it has been rooted in Vedas and has been fleshed in Upanishads. This Hindu law system, as to property, is based on two aspects. This entire Hindu law system, as to property, was based on a concept that especially amongst Hindus, based on Manusmriti, there were different works done by different jurists. I will not take into all details, but I will make you conversant as to the same. Why there were difficulties, why our better part, called as better part, and women were not given any right to property. Very religious authorities, very just authorities, they have blatantly refused right to property to our better aspect or to the woman, to the female. And for that purpose, this Manusmriti was further worked upon, and there were two schools of Hindus found. They were founded on these basic premises. Firstly, there was Mitakshara school and there was Dayabhaga school. Of these two schools of Mitakshara and Dayabhaga, I will take you only to the speciality of these two schools. One was patriarchal system, other was matriarchal system. You'll find today also in India, Hindus are divided into two factions, into two groups, into two schools of thought. First school of thought of Hindus that relates to matriarchal system, second relates to patriarchal system. Matriarchal means mother. So mother is the center of the family. Other is patriarchal, father is the center of the system. And accordingly, especially in Bengal province, today's Bengal province, that today includes Bengal, Orissa, and some part of Bihar. This is called as Bengal province then. In Bengal province, there is Dayabhaga school of Hindus. And Dayabhaga school of Hindus, it provides for matriarchal system. So mother is the center. All rights are vested in mother's hand. Even mother and female or the women are entitled to proprietary rights. This is a speciality of this Bengal school or Dayabhaga school. While rest of India, rest of the Hindus in India, they belong to patriarchal system. That is called as Mitakshara school. This Mitakshara school is a patriarchal system. Father is the center of the system. Male is the center of the system. Therefore, these two schools are diagonally opposite friends. In one system, male is the dominant factor, male is the center point. In other system, female or mother is the center point. And accordingly, our laws were divided into two factions in the beginning. Our main issue, especially in rest of India, excepting Bengal province, related to this Mitakshara school. We all in Pune, we all in Maharashtra, we belong to Mitakshara school. So, nicety of Mitakshara school was, female had no rights. No doubt, if we read the rich glories of the Hindu system, you'll find there were great such women, female, they were given respect, but no property. In our family, mother and grandmother, they were treated as goddesses, but without property. Because as per Mitakshara school, female had no rights into property. On one side, we respected them like goddess. On the other side, they were without properties. They had no property rights. This was the concept in respect of Mitakshara school. However, in Dayabhaga, female were given equal right with reference to male. Daughter was given equal right with that of the son since thousands of years. So from thousands of years, we had two avenues amongst Hindus, patriarchal wherein only male were given rights and matriarchal wherein male and female were given equal rights. Based on these premises, we have to come to today's subject, especially in respect of Mitakshara school. In rest of India, excepting Bengal school, in Mitakshara, what happened? The female, they had only two rights. Very rich Hindu system, respectable Hindu system, it suffered a great setback. And that setback was, female were not treated equal at par with male, and they were given only limited aspects in property rights. First, maintenance. Right to maintenance only. To live only. Necessary to live only. And secondly, the right was given was called as Stri Dhana, her personal ornaments like Mangal Sutra and personal ornaments called as Stri Dhana. Only these rights were recognized. No rights into land, no rights into house was recognized as per this very rich heritage Hindu system. This rich heritage Hindu system denied all these rights to our Hindu female. On the other hand, the matriarchal system of Dayabhaga in Bengal, they recognized for thousands of years rights of female at par with male. Both were treated equally amongst Dayabhaga. On these premises, This system continued till Britishers came in India. Till British people came in India, the Hindu female, she had no proprietary right. She was respected in house, but when the property matter came, she was not given any right into property. Especially amongst Hindus, then the law was very simple as to property. Law was very simple as to family. Law is very simple in respect of co-parcenary. Friends, so as to understand right to property concept, let us first understand 4 simple key concepts of Hindu system. Every person, every law student must be conversant with these 4 key concepts. And these 4 key concepts, they are firstly Hindu family, Hindu joint family, Hindu co-parcenary, and ancestral property. Ancestral property is the center point around which entire Hindu property law rotates. This is the axis around which entire Hindu property law rotates. And to understand this, let us see what is Hindu joint family. Every now and then, we speak of Hindu joint family. What is Hindu joint family? And you will find there is a very wider notion of Hindu joint family. What is Hindu joint family is a family having common ancestor, descendants from common ancestors, plus wives of the male members, less married daughters, who are joint in food, joint in worship. They are said to be the members of the joint family. 3 yardstick are necessary, that they shall be having joint in food, joint in residence, and joint in worship. Then such members, they constitute Hindu joint family. Who are the members? Common ancestor. Then descendants from common ancestor. Then wives of the male members coming from other families. They constitute Hindu joint family. And daughters of this family, when they are given into marriage to other families, then they are to be deducted from this family. This is what is Hindu joint family. Then this Hindu joint family, as has been observed by jurist Mullah, Sir Dinshaw Mullah, in his book called as Principles of Hindu Law, he says that there is no need to have any property in Hindu joint family. To constitute Hindu joint family, we have not discussed that there should be the necessity of property. Hence, Mullah says that there can be a Hindu joint family of beggars also. There is no need of any property. Based on this, we go to the next concept. Next key concept is as to ancestral property. Every now and then, you take out any book on Hindu law, you take out any judgment on succession law, you will find a key word called as ancestral property. No discussion is conclusion complete unless we refer to the concept of ancestral property. Let us, friend, therefore see in very simple language at elementary level of law student, I will tell you what is Hindu joint family. So Hindu joint family is a very, very simple concept to understand. Hindu joint family in the hands of a person like me, a Hindu, is a property coming from father, father's father, or father's father's father. So property to me from my father, father's father, or father's father's father is ancestral in my hands for my son, son's son, or son's son's son. So there are 3 degrees or generations upwards, and there are 3 degrees or generations downwards. And myself, how many degrees? How many generations? 7. And hence, in Hindu system, this is also styled and called as 7 degrees of representation. So this is ancestral property. So whenever concept comes as to ancestral property, one thing is sure, property has come from ancestors. Therefore, ancestral property. Then this ancestral property and Hindu joint family, when taken together, constitute co-parcenary. What is called in Marathi as Purusha Mandal. So this co-parcenary is a concept wherein there are 4 elements involved. Only male members within 4 degrees or 4 generations holding ancestral property. When there are male members only, they are within 4 degrees and holding ancestral property, then that Hindu joint family with ancestral property constitutes co-parcenary. So what is difference between Hindu joint family and co-parcenary? This is very essential, friends, as a law student, to know our further discussion in coming 1 hour's time. So, what is Hindu joint family? Any member, male or female, any generations, however, constitute the Hindu joint family. Property not necessary. For co-parsonery only male members within 4 degrees or 4 generations. And what is the utmost important, essential, basic element to constitute co-parsonery is there shall be ancestral property. If there is no ancestral property, then there is Hindu joint family, but no co-parsonery. And hence, Jurist Mullah, Sir Dinshaw Mullah has observed that there can be no co-parsonery of beggars. So, there can be Hindu joint family of beggars, property is not required. But there can be no co-parsonery of beggars because to constitute co-parsonery, property is essential. This is the basic distinction. On these premises, we have to proceed to today's female position. So, this position continued whenever in any Hindu joint family, there were male and female members who were the owners of the property. Say, for instance, there is a grandmother, there are children, there are sons and daughters. This is a family. Who are the owners of the property? Is grandmother owner? Is mother owner? Is sister owner? Is daughter owner? No. In past, this female, even though they were members of the Hindu joint family, were not owners of the property. Who were the owners? Only male members. That too within 4 generations. And there must be ancestral property, then there was a co-parsonery. So this was the concept to understand. Now, based on this system, if whenever father died or any co-parsoner died, what happened to the property? What happens today if any Hindu dies? What happens to his property? Today, if any person dies, Hindu Succession Act applies, and then there are provisions contributed in Hindu Succession Act, especially Section 8, Section 9, Section 10, Section 11, Section 12 and Section 13. They therefore provide for a series of sections for succession. And today what happens? If a Hindu dies, then his mother gets a share, his widow gets the share, his daughter gets the share, his son gets the share today. Then what happened in past? If succession applies, all male and female, they get the shares on succession. What happened in past? There was no succession. Surprisingly, you will find, before 1956, amongst Hindus, there was no succession. Daughters were not given any share. Widow was not given any share. Mother or any female was not given any share. Who were given shares? Only male members. That was called as survivorship. Therefore, up to 1956, for so many centuries, so thousands of years, in India, all Hindus were regulated by very simple equation called as survivorship principle. What survivorship means, I will tell you. If there are, say, 4 members or 4 brothers, in past, before 1956, before 17th June 1956, if before 17th June 1956, there had been 4 family, there were 4 brothers, and 1 brother died. What happened? His share devolved on remaining 3 brothers, called as survivorship principle. His share was not given, friends, to his widow, his mother, or his daughter. They were not given any share. Today what happens? If today any person dies or this brother dies, his share devolves on whom? His share devolves on his widow, his mother, etc. In past, this was not done so. What was the principle known as? Survivorship. So, all of you are clear with the concept as to succession and survivorship. Principle of survivorship means, in past, amongst Hindus, if any Hindu he died, then his share, property share, devolve on other male members of the co-parsonery only, not his widow and say his mother and his daughter. That is called as succession. If it is given to mother, daughter, etc., succession. If it is given only to male members of the co-parcenary, survivorship. So, we come to the first deductions or inference that, what is the inference of this discussion? In past, before 1956, what was the consequence of death? A person died, survivorship was the principle applicable, and only male members they could get, and other female members were absolutely excluded from getting the property. This continued till British period. I will tell you, our female in past, our sisters in past, our mothers in past, they had no proprietary rights, even after death. What happened? Britishers were the first administrators who had attempted to do justice to Hindu female. These Britishers or the British administrators, they started reforms in India for Hindus, conferring rights on our sisters and female members. There had been various legislations in past. Of various legislations, as a law student, I will take you only to one legislation of 1937. In 1937, Britishers, they enacted the law called as Hindu Women's Right to Property Act of 1937. Britishers, they had done a magic. Really, in the year 1856, there was a law as to Hindu Widows Remarriage Act. Then there was Gains of Science Act. Then there was Hindu Inheritance Act. And then the real magic was done by the Britishers. Thank them. All our females shall thank Britishers, because Britishers were the people who started giving proprietary rights to our Hindu female. And the first major step was taken by Britishers in the year 1937. In the year 1937, the Hindu Women's Right to Property Act of 1937 was enacted. And the magic was done. Revolutionary change was made only by 13 sections. How exhaustive the law is, friends, is not material. How drastic provisions are incorporated is material, has been exhibited by only 13 sections of 1937 legislation. What happened in past? For thousands of years, no right to property to female. For the first time, during British period, in the year 1937, proprietary right was given to Hindu female. And this proprietary right was given, I will discuss with you in a couple of minutes with this reference of 37 law. Up to this time, if a Hindu co-partner died, then his widow was left without any property. She had to live at the mercy of the other male members in the family. Even though she was a widow of a very rich person, but she had no property right, she has to absolutely live at the mercy of other male members of the family. Position has been changed by Britishers first time. In the year 1937, this law of 1937 has been enacted, friends. And when this 1937 law has been enacted, what was done? For the first time, when a Hindu died, then after his death, his widow was given certain right. First time in the history of Hindu law. After thousands of years in the year 1937, Britishers, they enacted such a law and held and provided that after death of a Hindu male, his property shall go to his widow. First time. But it was not absolute giving the property. It was said limited or life interest was created in favor of such a Hindu female. What is life or limited interest? What is absolute interest? Absolute interest means when she gets the absolute ownership. However, absolute ownership was not given. Ownership in totality was not given. Only life or limited interest was given. Means, in short, when husband died, property came to the share of widow, and the widow enjoyed the property during her lifetime. She could enjoy. If it is agricultural land, she could take the usufruct or the income or the food grains or the crops. If it is a rented house, she could get the rent, but she could not sell. That is limited interest. Limited interest means she could enjoy, she could possess, she could get the fruits thereof, but she could not sell in past. That is limited interest. But at least something was given after a couple of thousands of years. From nothing to something was the journey up to 1937. That was the first such provision wherein for the first time limited interest or life interest was given to her. We, the male community, was very selfish. Hindu male community was very selfish, because what happened, that right was given to her for her lifetime, enjoyment for her lifetime, but with a condition. What is the condition? That after her death, property will come back again to some male. Male property for a temporary period during her lifetime had been given to her, and after her death, it was coming back again to some male member in the family. That was the consequence in respect of 1937 legislation. But something was given. At least subsistence was given to her, and she was happy that during her lifetime at least she could enjoy the fruits of husband's property. This happened. Then in the year 1947, India became independent. In the year 1950, Constitution came into force. The principle of equality was enshrined in the Constitution. Dr. Ambedkar, very jealously, very religiously, he incorporated right to equality in the Constitution, whereby male and female, son and daughter were made equal. This all happened in Constitution. This all happened in the books, but not in the practice. Even such fundamental rights were given to us. They were theoretical fundamental rights. No practical fundamental right to Hindu female was given by the Constitution, because our personal law system did not allow Hindu female to be equal with the male, irrespective of the coming into force of the Constitution and the provisions as to equality in the Constitution. But equality provided, all shall be equal, like should be treated alike. Irrespective of all this, what should have been the consequence? If everybody is equal, son and daughter are equal, then the daughter would have been given equal share in the family property with the son. This was not done. Irrespective of the Constitution, irrespective of the right to equality, this was not done. And for this purpose, it was thought fit that there should have been law reforms. And accordingly, a Hindu Code Bill Committee was constituted under the leadership of Dr. B.N. Rao. This very Dr. B.N. Rao, who afterwards became the consultant to the Constituent Assembly, and subsequently he became the first judge of India in International Court of Justice. Under his leadership, this Hindu Code Bill Committee was constituted, and when Hindu Code Bill Committee was constituted, it was to draft the Hindu Code for all Indians. But unfortunately, on the point of rights of female, there was controversy. On right of female, there was a controversy, and Dr. Babasaheb Ambedkar, he was for absolute equality of male and female. Male and female should be treated equally amongst Hindus. However, late Jawaharlal Nehru, then our Prime Minister, he did not agree with this proposal. These two high leaders, high position leaders, high profile leaders, they differed in their opinions. Jawaharlal Nehru was saying, let us not treat them equally at this level. It is a newborn Republic of India. While Dr. Ambedkar was very insisting as to that male and female should be given equal rights. Son and daughter should be given equal rights. As of you know, Dr. Ambedkar resigned from the ministry. He was law minister then. He resigned. He said, okay, then I will leave this ministry. He left the central ministry at the behest of, for the cause of Hindu female. He resigned. And then accordingly, the parliament then constituted the functioning. When parliament started functioning, Hindu Code Bill never came into existence. And 4 laws were enacted. Which 4 laws were enacted? Hindu Marriage Act, 1955. Adoptions and Maintenance Act, Minority and Guardianship Act, and fourthly, the Hindu Succession Act of 1956. This law came into force on 17th June 1956. That is our today's subject. Why I told you this entire history, so as to make you understand why at all this subject is important in India, and how for centuries and centuries Hindu female were denied rights. For the first time, this law was enacted. Came into force on 17 June 1956. And when this law was enacted in the year 1956 and came into force on 17 June 1956, then this law did consist only of 30 sections. Of these 30 sections, what happened? Section 1 to 4 are definitions. Then section 5, 6, 7, 8, 9, 10, 11, 12, 13, they provide for succession. Section 14, 15, 16 provide for female position. and female succession. Then sections 17 to section 29 provide for general principles, and section 30 provides for testamentary succession in respect of Hindu. Based on this, we'll come to the today's subject entry into the subject. Let us see then what happened by virtue of this act, how our sister, how our female, she got a right in property. And such a female was given a right in the property by virtue of succession and not by survivorship. What was required to be changed? If at all we wanted to give, if at all we wish to give and desire to confer on female rights to the property, what should have been abolished? Survivorship. Because survivorship was the gimmick, whereby rights were given only to male and not to female. And therefore, so as to do away with this evil, it was necessary that principle of survivorship shall be given up, and it should have been substituted by succession. And for the first time, this succession law came into force. And what happened by this succession law? By virtue of this succession law, now the heirs were defined, and accordingly, now son, daughter, mother, etc., they were made class 1 heirs. We know in the schedule to the Hindu Succession Act of 1956, there are 4 categories of the heirs: class 1, class 2, agnates and cognates, of which class 1 heirs are very material. And accordingly, in respect of class 1 heirs and their succession has been stated in section 6 of this law. Real woman empowerment or beginning of woman empowerment after independent, in independent India, after independence comes with section 6. This section 6 has been substituted in the year 2005. So there are 2 versions of section 6. Old section 6 and new or substituted section 6. Let us first see old section 6. Old section 6 provided when a male Hindu dies, after commencement of this act, having his share in the Mitakshara co-parcenary property, then his share shall devolve on the surviving co-parceners by the principle of survivorship and not as per this act. Provided that if he is survived by any female of class 1 or any male heir claiming through such a female heir of class 1, then his interest shall devolve on his heirs as per this act and not by survivorship. This was old section 6. I will make it simple. This is little technical sections. This section comprises of 2 parts. First, this incorporates survivorship as well as succession. Because the system in existence for hundreds and hundreds of years cannot be undone in one stroke, because people, they must be used to the change, and change must be slow and gradual. For such a gradual and slow change, provision has been made in section 6 old. Section 6 old provided that first there is survivorship and then there is succession. There is mechanism provided. There is inbuilt mechanism provided in section 6 of survivorship principle as well as succession principle both. You'll find even after commencement of 1956 legislation, there is a place for survivorship. Till there was a place for survivorship, and survivorship and succession were the 2 aspects. They were conditioned. What was the condition? What are the general principles stated? When a male Hindu dies, after commencement of this act, having at the time of his death his interest in the Mitakshara co-parcenary, then his interest shall devolve as per the principle of survivorship and not as per this act. Even though this act was made applicable, from 17 June 1956, irrespective of that, to some extent, that 1,000-year-old law was continued in India. It was not by one stroke. It was not stated that from today, no survivorship. This is not stated. What was stated? Survivorship will continue till this proviso applies. Survivorship or 100 years old principle will apply unless the proviso applies. And when proviso will apply? When this today's Hindu Succession Act will apply, and there was a condition provided that whenever there are two classes of heirs present, which classes? Any female heir of class 1. Any female heir of class 1, and who are female heir of class 1? Mother, widow, daughter, daughter's daughter, etc. So, in the first instance, female heir of class 1. If she is present, what will happen? If a Hindu dies and he is survived by, say, daughter, or say mother, or say his widow, what will happen? 1,000-year-old law will not apply. 1,000-year-old law will not apply, and this today's law, which is made applicable and enforceable from 17 June 1956, will be applicable. So what was the condition for applicability? Only first instance, female class 1 heir. There should be daughter, there should be mother, or there should be widow, etc. If they are applicable, read this law. If they are not present, read Manusmriti, read Mitakshara law, read Puranas and read Vedas, and then you can read all past texts. And if somebody comes and says, daughter says, I am present, shut the books of Manusmriti. Don't read all books. Let us not read Upanishads. Let us read only 30 section Parliament's law. So it depends on what? Presence of which heir? Female heir of class 1. Or there is other category also stated. Or any male heir claiming through female heir. And there is one simple illustration to avoid the confusion. Say that there was a daughter, she was married, and daughter has died, and there is daughter's son alive. Grandfather or father dies. If daughter was there, what would have happened? This act would be applicable. Survivorship not applicable. Older law not applicable. But today daughter is not alive. But daughter's son is alive. Proviso says sufficient. Either there shall be a female class 1 heir, or there shall be a male claiming through female class 1 heirs. Then this act is applicable. Is concept clear? So this was the very simple aspect whereby this act was made applicable by the good offices of section 6 of Hindu Succession Act. This very Succession Act provided for a concept called as notional partition. Nowhere in the book the word notional partition has been used, but all judgments, all discussions, all lecturers, they use the word notional partition as a consequence of section 6. This section 6, when made applicable and when succession took place, that was said as to notional partition. And the concept of notional partition has been explained in this law itself, but not under the name and style of notional partition. It is said, and his interest in the Mitakshara property, shall be deemed to be his interest immediately before his death. So, if there is a large family, say that there are 10 male members, what will happen? Co-parcenary. And then one person dies after commencement of this act, having at the time of his death his interest in Mitakshara co-parcenary, what will happen? What is his share? His share shall be as if he died before his death, partition taken place. So, say for instance, he died on 1st. Then law will say on earlier day, his interest is to be calculated. Let us take that interest and then let us have succession in respect of his interest. That is what section 6 says. Then you will find there are further sections in respect of male and female succession provision have been made. This entire historic law, any student of law, any lawyer, or even a person like me practicing for 46 years and has reached 70 years of age should have one theme of this law. To understand this law from right perspective and then to write answers as well as to teach the law even at early stage, you can have relook into this law. And to have relook into this law is to study section 4, section 6, section 8, section 19 and section 30 of this law. You'll find there is a very nice, beautiful combination of sections. While drafting of this law, the drafting committee of the Parliament of India has taken into consideration this golden thread of the sections. What is the golden thread of the sections? Any law student or any professor or anybody as a student or as a teacher of this law or as a lawyer, he should know this binding and the binding force between these few sections. Which sections? This is the heart of this entire law. What is the heart of this entire law? Section 4. Then section 6. Then section 8. Then section 14. And then section 19. And then section 30. Only you read these sections and you will be master of Hindu law. You can teach Hindu law to others if you understand theme interconnecting these sections. Let us see what is section 4. Very interesting section, friends. Usually we the lawyers do what? We start reading provisions. But we don't read the elementary sections. This very elementary section, section 4, that provides the relationship between 1,000-year-old law and the new law. This relationship is regulated by section 4. Previously, where the law was required to be found? Vedas, Shrutis and Smritis and Puranas and Upanishads. And today, where we find the law? Succession Act. So, question is today, whether we are required to read Vedas, Upanishads, Manusmriti, Puranas, etc., or whether only to read the Hindu Succession Act. And answer is not either way. It is not said that you shall not read the Vedas. It is not said that you shall not read Upanishads. Yes, till today they are relevant in few areas of practice. Which area? We'll discuss. So, section 4 is the elementary section which provides insight to you when our past law is relevant and when our present law is relevant. Of the two, which is to be applied today. And then section 4 has very interesting wording. Section 4 had two parts, friends. Section 4.1 and Section 4.2. Section 4.2 has been deleted by 2005 amendment. There is only now Section 4.1a and Section 4.1b. Section 4.1a provides that any text, any rule, or any interpretation of Hindu law, or any usage or any custom of Hindu law prevalent immediately before commencement of this act shall cease to exist, for which there is express provision is made in this act. Very simple. By only 2 lines, the Parliament of India has defined when to read the past law and when to read the present law. This is the connection. What is the connection? What is not to be read? What ceases to exist? What is not applicable today? 5 things. 5 things are not to be read today. Any text, any rule, or any interpretation of Hindu law, or any usage or any custom of Hindu law becomes irrelevant today when? For which express provision is made in this act. If there is an express provision made in this act, don't read the past. But if there is no express provision made in this act, then read the law in text. So today, nobody can say that law in Vedas is not relevant. Nobody can say Manusmriti is not relevant. Yes, today also Manusmriti is relevant. Today also law in Vedas is relevant. In which area? For which there is no provision made in this act. If act is silent, if act is specific, then this prevails over all. If act is not specific, act is silent, then read the past. This is simple equation with reference to section 4. So this is relationship between earlier Hindu law and today's Hindu law. But the parliamentarians, at the stake of all their wisdom, also incorporated subclause B. And subclause B provided that not only past Hindu law is relevant or not relevant based on this discussion, but other laws. Other laws means accepting Hindu law. If some other laws they are applicable to Hindus, then they shall not be applicable to Hindus if there is provision made in this law. They will continue in force but will not apply to Hindus because there is a provision specifically made to Hindus as per this law. So friends, there are 3 things now. Before we come to any concrete discussion, as a student of law and as an advocate or as a lecturer, you must know 3 things co-relationship. What is the threefold relationship? 1, past textual Hindu law, Vedas and Smritis and Upanishads and everything. Second, the present law, Hindu Succession Act. And thirdly, other laws, other than Hindu laws. So, today to Hindus, we are primarily regulated by which law? Hindu Succession Act, 30 sections. But if these 30 sections are silent, then old Hindu law or the other laws. If there is provision, don't read those two. If there is no provision, read both those two. This is the simple relationship to understand. Based on this now, we go to the further consequence. Section 6 provided for class 1 heirs and shares to class 1 heirs. But this was very deceptive. As soon as this act was passed and amalgamated, the Hindu female and daughters especially were very happy. Yes, we have got right. But this was very deceptive one. All the female were deceived at the end of the male community. The male community who were having dominance over properties for thousands and thousands of years. Now by constitutional force they were required to part with the property, but they were not ready to give everything at one stroke. They started giving in piecemeal, slowly. What was the first attempt by Britishers? Limited interest. Now from nothing and from zero to limited interest. From limited interest, now in the year 1956 to some interest. Zero interest, limited interest, and now by 56 legislation, some interest. Let us see what is this some interest. How our female, how our sisters were deceived at the instance of the brothers. How male community, they did not give everything at one stroke. Female were required to fight till 11th August 2020. This is the long battle between male and female over proprietary rights. Let us see what happened here. Say for instance, this Hindu Succession Act came into force and there was a Hindu female class 1 heirs. So let us take very simple case for your understanding. There is a father, there is a co-parcenary of father and son, and there is a daughter in the co-parcenary. Before 17 June 1956, what happened, friends? If father died, what could happen? There was son only. Son became absolute owner because principle of survivorship. In case of co-parcenary, there was a principle of survivorship. Female was not given any share. What happened in the year 1937? Widow was given share, but here is a daughter. So she could not get anything. But by virtue of this, what happened that she was given a share? In what? Say for instance, father died. Did it mean that son and daughter got equal shares? Say for instance, father had say 10 acres of agricultural land. If father died after 10 acres of agricultural land, whether by virtue of this act, daughter got 5 acres and son got 5 acres? No. This was not the division. This law was deceptive equality. Because what happened? There was a co-parcenary. Who are the members of the co-parcenary? Father and son. So this son said to the sister, look, let us first sit together. Father died, he had only 5 acres. I was a co-parcener, I had 5 acres. So I will take 5 acres as co-parcener. So at the time of the father's death, what was his share? Only 5 acres. That will share equally. So in 5 acres, half was given to daughter, that is 2.5 acres. 2.5 acre was given to son as sharer. And 5 acres was given by him, taken by him as co-parcener. So he got 5 acres as co-parcener and 2.5 acres as heir, and he got 7.5 acres. She was given only 2.5 acres. This was the equality. This was the succession taking place by virtue of 17th June 1956. And therefore, there was no perfect equality even after independence, even after promulgation of the constitution. Not only that, even after 25 years thereof. And therefore, there was the demand from the Hindu female community. Education inculcated therein, education imbibed in their minds that we shall be equal in proprietary rights also. And they started claiming equal proprietary rights. And when they started equal proprietary rights, the first state in India to do it was state of Kerala. State of Kerala, in the year 1973, provided for this act, which came into force from 1975, the Kerala Hindu Joint Family Abolition Act 1975. In one stroke, what Dr. Ambedkar wanted then was done by Kerala state for the first time in the year 1975. And in Kerala, you'll find from 1975, there is no co-personary, there is no Hindu joint family as such, there is only Hindu family. Means in state of Kerala, this concept of ancestral property has been absolutely done away with. By birth, there is no interest in Kerala now. The holder's death will decide the shares equally. And therefore, perfect equality has been brought in the most literate state in India, that is state of Kerala, since 1975. But as this was going on, friends, I think that I'm not boring you. It is not hyper-technical. I'm trying to simplify and bringing it to student level. So friends, bear with me for some more time and hope you'll be enlightened for that. So, when this act came into force, and state of Kerala was the first state wherein they abolished the Hindu joint family. Then, other state also started learning from state of Kerala. In the year 1987, state of Andhra Pradesh. In the year 1990, Tamil Nadu. In the year 1994, Karnataka. And on 22nd June 1994, Maharashtra state. They also provided for state amendments, wherein they attempted to do justice to female, bringing male and female on equal footing, daughter and son on equal footing. This amendment in Maharashtra state, in a lighter vein, is also said to be Mr. Sharad Pawar amendment. Fortunately then, Mr. Sharad Pawar, he was the Chief Minister of Maharashtra state, and it is said by a joke that he had only a daughter, so he was favoring such legislation in favor of daughters. But nevertheless, he has done really justice to female in Maharashtra state, applicable from 22nd June 1994. Let us see what was this 1994 law. In one sentence, this 1994 law provided, since then, I will not take you to the sentences and the sections and the technicalities. Conclusion was that son is equal to daughter. For the first time in Maharashtra, it was said son is equal to daughter, and daughter was made a co-partner. As daughter was made a co-partner means she was given status of a co-partner, including proprietary rights. Means in father's property, what happened? If father died, son is equal to daughter. So son is equal to daughter means what? 1/2, 1/2. Earlier, son is equal to daughter meant 1/4, 3/4, because she was given 2.5 acres. Brother was given 7.5 acres. So she was given 1/4 and he was given 3/4. Now, real 1/2 and 1/2. Real 1/2 and 1/2 means if father died, then 5 acres will be given to daughter and 5 acres will be given to son, was the law in Maharashtra state from 22nd June 1994. Female were again happy. Earlier was Rishi and Muni, they given, Vedas they have given 0. The Britishers, they have given at least life interest. This 1956 legislation has given at least 1/4, 3/4 formula. For the first time in Maharashtra, it was 50-50. It was equal status was conferred on the female by virtue of this 22nd June 1994 legislation applicable in Maharashtra state. But, friend, inadvertently, a mistake was left. And it was said that those daughters who are unmarried on 22nd June 1994 were treated like son. In doing so, in doing such justice, some injustice was caused. Which daughters were treated as son? Unmarried on 22nd June. And who were married then? Who were married? 1/4, 3/4. Married 1/2, 1/2. So this discrimination in the over-enthusiasm, so as to do away with the discrimination between son and daughter, discrimination was created between daughter and daughter. Are you getting me correctly? See, earlier was a discrimination between son and daughter. because earlier daughter was not given share. By virtue of 56 legislation, she was given 1/4 and he was given 3/4. So there was discrimination. Now in Maharashtra, it was desired to do away with this discrimination. Daughter should be given 50, he should be given 50. Both shall be given equally. In this over-enthusiasm, a mistake remained. Which daughter? Only who was unmarried on 22nd June. And married then? 1/4, 3/4. Here, 1/2, 1/2. This was the rather lacuna left in this law. I will give a very simple illustration before we proceed to next part of the case law discussion. What happened? Very simple but consequential part was, say for instance, there was a father and he had say one son and 2 daughters. And in Maharashtra state especially we know, there is a marriage season during May and June, which is called in Marathi as Vaishak. So during this month there is a marriage season. These 2 daughters, one daughter was married on say 19th or 20th June. Other daughter was married on 25th June. What happened? Say for instance, these were the twins. Of the twin daughter, one was married 2 days before the amendment and one was married after 2 days of the amendment. What happened? The daughter, if father dies, the daughter who married before the amendment, she could get what formula? 1/4, 3/4. And daughter married after amendment, she would get 1/2, 1/2. This was the discrimination left. You are getting me correctly? So in the beginning, nothing. Then by 37, life interest. Then by 56, 17 June 1956 legislation, 1/4, 3/4 formula. And then by virtue of this 1994 Maharashtra legislation, 1/2, 1/2 sometimes and 1/4, 3/4 sometimes was the consequence. This injustice was being faced and faced. This was realized. But you will find law moves at a very slow pace. This happened after 56. There was demand for absolute equality. As there was growing education, the female section started demanding absolute equality. Why not equal? Why not this marriage to be done away with? And therefore, accordingly, you will find in the year 2005, there was the Law Commission's report. Law Commission of India had a meeting in ILS Law College, Pune, in association with one NGO from Goa, and they had lengthy discussion and discourse on this topic at ILS College, Pune. Most of the dignitaries and lecturers and professors were called upon to participate in the discussion. And as a consequence of the discussion, a law was desired to be framed to do absolute equality. And absolute equality was struck, balance was struck by passing of the new legislation or amending the existing law. Law was to be amended, and the Law Commission, after its entire discussion, submitted a report to the Parliament of India called as 174th Report of Law Commission submitted to the Parliament of India. Report was submitted to the Parliament of India, and along with the report, there was proposed amendment draft was also annexed. When this Law Commission's report was submitted to the Parliament of India, along with the draft report that was received by the Parliament, Parliament considered it, and then Parliament thought it fit. Yes, this would have been done in the year 1956 itself. We're at fault. This would have been done by us when? Immediately after independence, about 50 years have been lost. And then in the year 2005, the Parliament of India passed an act. The Hindu Succession, into bracket amendment, bracket complete act, comma, 2005. Accordingly, 2005 amendment has been enacted and passed by the Parliament of India, which came into force from 9/9/2005. And therefore, by this amendment, absolute justice has been made. So let us see the stages. First, 0. Then 37, absolute limited interest. Then 17 June 1956, some interest, 1434 formula. 1994, 22nd June 1994, unmarried daughters, 100%. And married daughters, lesser interest. And absolute interest has been given, and final stage of equality has been reached by virtue of the Constitution of India, whereby son is equal to daughter, absolutely no qualifications, marriage, etc., nothing. And son is equal to daughter was the formula made by this amendment. Let us come to today's amendment. Let us see that amended law which came into force from 992-2005. This law which came into force from 992-2005 provided for this amendment. This amendment is said to be consisting of this section 6.1, section 6.2, section 6.3, section 6.4 and section 6.5, only 5 subsections are provided in amended section 6. Friend, usually what happens, whenever amendment is made in the section or any part of the law, some words are taken here and there. This is called amendment. Something is added, something is taken away. But when entire section is taken away, and that is substituted by another section, new section. So this is not a word change or sentence change or paragraph change. Entire section is taken away and that is substituted by new section. This is called as substituted amendment. So there is difference between amendment and substituted amendment. When some portion is changed, amendment. When entire law has been changed, substituted amendment. And there is an interpretation of statute provided here. What is interpretation of statute? The people who have learnt the subject of interpretation of statute, they must be knowing. There is different rules of interpretation for ordinary amendments. Usually, ordinary amendments, they apply from the date of the amendment unless they are made retrospectively applicable. However, whenever there is a substituted amendment, that shall be deemed to be in force from the date of the original act. Try to understand, friends. I will make you understand again. Amendment is made on what date? 9/9/2005. This is a substituted form of amendment. Even though this came into this act, this has been incorporated and brought into this act from 9/9/2005. What is the deeming consequence? What is the fiction of law? That this amendment, which has been done in this act today, shall be deemed to be in force from 17th June 1956. Are we getting correctly? Even though this is brought into today, for the legal purposes, that shall be deemed to be in force from that day. This is the consequence. So, by all means, the law was made, daughter was given share. After centuries and centuries fight of the two sexes, it resulted into success. They were given absolute share. They were given equal status. Daughter was made a co-partner. What is said? I will read only relevant provision of this section. Very tricky section. Very tricky section. And rather defective also. How sometimes it is said that the people sitting in air-conditioned offices make the laws for the people tilling in their lands in the noon. So lawmakers are sitting in air-conditioned offices. Law is made for whom? The laborers working in the field under the sun. These two conditions of their needs and the mind setup of the lawmakers is different, and therefore there is a defective legislation. This is the defective legislation. How this defective legislation was made, I will conclude within the next couple of minutes now. When this law was made, females were absolutely happy. Our daughters were absolutely happy. At least after centuries and centuries, we got justice and we got equal share. Previously, who had not given to them? Religion, Manusmriti, Vedas, Upanishads, they had done injustice to daughters. Then, to some extent, justice was done by law by the Britishers. Then, to some extent, justice was done by the Indian Parliament. Now, irrespective of this, justice was denied to them by courts. Courts are there to do the justice to the female, but by virtue of next 15 years battle which we'll discuss, the rights which are conferred, denied rights were conferred on them, they were not given in a right spirit to the female, and this discredit goes to the courts. Courts, they have denied rights to them for next 15 years. First, they fought against religion. Then there was a fight between brother and sister. There was a fight between male and female. Now, this fight was over. Law said that Parliament said, now we will not come in between. Both of you are equal. But whether you are really equal or not, courts took 15 long years to decide. 15 long years to decide. What to decide? Whether really male is equal to female, and whether what Parliament has said that son is equal to daughter, what is the extent and truth thereof. This truth has been discovered by the court after 15 years long battle. I will take you through this battle. Shall I continue? What is your tolerance for next 15-20 minutes or not? May I continue for next 15-20 minutes? So friends, new section 6 provides for this bothering you for some time more. I'll be compensating you. I'll be giving a small note to you also. And a note about of 60-70 pages will be given to you for your ready reference. So at least for that, you bear with me for next half an hour's time. So friends, we come to this legal battle now. So Parliament, the books were denied, Parliament's law was set aside, and now matter went to the High Court. For the first time in India, interpretation of this new section 6 came into force. What was new section 6? How that was badly worded, how that was wrongly worded, and it has been said. New section 6 says, on and from the commencement of the Hindu Succession Act, the interest of Mitakshara shall devolve as per this law, and A, B, and C, 3 clauses. It is firstly said that daughter is made a co-partner, and she shall have such rights and shall have all the liabilities. The words are very interesting, on and from. When from she is made a co-partner, when she shall have rights, on and from. On and from means what? On means what and from means what? We'll discuss on and from. And the simple word on and from required High Courts and Supreme Court 15 years to decide. High Court and Supreme Court, they took 15 long years only to decide what on and what from means. And let us see a short history of this litigation so as to make you understand how our female empowerment, my today's subject is female empowerment, how this female empowerment took such a lengthy time, such a long time to fight sometimes against male, fight against religion, and to fight against courts sometimes. And this long battle started from first time in Karnataka High Court. First issue forever arose after commencement of this act in Karnataka High Court, and was the case of Pushpalata versus Padma. In case of Pushpalata versus Padma, issue was whether this act is prospective or retrospective. Whether this act and such a status is conferred on Hindu female from 992005, or whether a daughter born before that, she could be benefited thereby or not. And the Karnataka High Court held that this act is retrospective. So this act is applicable to daughters born before 992005 also. This is retrospective consequence. Then, immediately within 1 year's time, there was a case before same High Court, that is Karnataka High Court, was the case of Prakash versus Fulavati. And again issue was whether this is prospective law or whether it is a retrospective law. And the Karnataka High Court said, yes, this is retrospective law. Benefit of this law shall be given to daughters born before 992005 also. So this was okay for Karnataka state. Immediately in Maharashtra, a case arose in Bombay High Court, and this case was The case of Sadashiv Sakharam Patil versus Chandrakant Desle, decided by Bombay High Court in the year 2010. Justice Roshan Dalvi Madam was the judge who decided this case. Issue was again before Bombay High Court. Whether this act is prospective or retrospective. Friends, those who are not understanding properly, I will explain in one sentence. Laws are having two fold of application. Prospective means law came into force on 9/9/2005. So this law will apply hereafter. Daughters born after this. Retrospective means that this law, which has been enacted and came into force from 9/9/2005, will act for daughters born before that also, was the controversy. Before daughters and after daughters who are covered is the controversy. In this case of Sadashiv Sakharam Patil versus Chandrakant Desle, Bombay High Court held no, this act is prospective only. Are you getting correctly? So from here, from Pune, we go up to Kolhapur, towards Bangalore, towards Karnataka. Up to Kolhapur, what was the law? Prospective. Only daughters born after 9/9/2005 will get law. As soon as we crossed the border at Kolhapur and entered into the border of the Karnataka, what was the law? This is retrospective. What was the consequence with reference to this law? If in this state, prospective. In that state, retrospective. And therefore, there was no certainty as to law. And as this happened,